All right, this will be a short video. I know everybody likes to hear like real world, real life examples, and this is a detective from the district attorney's office. I had filed a criminal complaint last week against the attorney that started the sewer authority suit. And of course, since it's the district attorney, they're all attorneys in there, and they investigated themselves and they found themselves innocent. Well, that's how the phone call started, basically. Is he called me up to tell me, yeah, the attorneys reviewed it, and they don't see any crimes here. There are a litany of crimes here, and I'm gonna have to agree with Steve on this stuff. Steve said, Steve just takes them into court and bangs them. But I just wanted to. The reason I filed the criminal complaint because I want to at least get the detective to actually start asking a few questions of these people so that they know that they're being watched, that there's outside eyes on them, and that what they're doing is not going to go unchecked, basically. Because they're running, they run these. Well, what they're doing is they're misusing statutes. It has nothing to do with the all caps name. It had nothing to do with the trust that's supposedly set up under your name. It has nothing to do with that stuff. Well, what's going on is you have public officials, public servants, that are misusing statutes and codes to deprive you of constitutionally protected rights, and that's really all it is. And when you call them on that in federal district court, when you file your Title 42, Section 1983 suit, they're going to have trouble answering you. They're not going to be able to answer you, and you've just got to structure your paperwork properly, and that stuff we'll be getting into in the near future on how to properly write a Title 42 1983 suit, and how to litigate it. You got to understand. It's always you got to understand what's in your paperwork, and when you plead something, you've got every pleading, every cause of action has a certain set of elements that have to be met. So if it's a contract dispute, you've got to prove that there's a contract, that there was an obligation in the contract, and that the contract was breached and it caused damages. So every element's got every cause of action has a certain set of elements. And listen, these statutes, think about these statutes actually, these are your law, okay? The statutes and these codes, these are your laws. The problem is that your public servants are not, they're abusing the statutes and the codes. Okay, the statutes and codes were written for your benefit. These are your laws, your codes. They're just being abused. They're being misused by these people, and this is what you have to call them on. And the people that have actually done very well with this stuff and gotten paid enormous amounts of money with this stuff have done just that. They basically will bring up the statute and code. It says, look, it says we were supposed to do this, and you did this, and because you did that, you violated this right, that right, and so forth. So that's really the gist of it. It's don't overcomplicate it with birth certificates and all cap names and all that stuff. It really has nothing to do with that. And don't get hung up on these. Don't get too hung up with titles and stuff, because when you're moving as the plaintiff and you're forcing somebody to answer you, none of that stuff's going to come up. Your citizenship, none of that stuff's going to come up. What's going to come up is what's in that pleading. Hey, look, the statute says that you're supposed to do this, and you did this, and because you did that, you violated my rights and you caused me damages. And that's really how basic it is. We don't have to complicate this any more than it is. And listen, we've had a lot of success using affidavits. We've actually gotten some pretty nice settlements using affidavits. But what's going to happen is a lot of times your stuff will get ignored by these people because they either don't care or they don't know. They're ignorant. They don't understand, and they just go forth and do what they're told. They don't they don't know what they're doing. And that goes down from the cops to your local bureaucrats, your local officials. So you got to learn how to go on offense. And to me, part of going on offense is the affidavits. It starts to set them up for things because you're telling them in advance, hey, listen, you're stepping on my toes, get off my toes. And if they don't do that, well, now you've got negligence, and really gross negligence, because you gave them fair warning and said, hey, what you're doing's wrong, and you ignored me. And that's stuff that can be used and can be folded into your federal district court website. And I know there's a lot of people in different countries, and they may not have the 42 1983 avenue to go down. So, but I do know of from talking to Steve, I do know people that have. He mentioned a couple men in one in Australia and one in Canada. They've actually had a lot of successes. You just don't hear about them. They don't publicize themselves. They don't, they're not out there. They're very quiet about it. But he said, from what he's told, that if done properly, if the remedies available for you there. You just got to dig through the stuff, and you have to put them on the spot, and you've got to go on the offense because they're always going to steamroll you on defense, and like I was told, expect the lower courts to sort of railroad you, to sham you. They're going to do that, and where you beat them is you beat them on appeal. And when you appeal something, you appeal all the things they did wrong. Not so much not the contents of the case, not the facts of the case. You're appealing the procedure. They didn't give me service of process. They didn't do this. They didn't do that. They violated Rule 602. They let the attorney testify and speak. So you're basically going after the procedure and all the errors they made in running the case the way they did. And the appeal court will kick it back, and that's pretty much where it'll end when they kick it back, because they can't correct the errors that they have. And the further to go on offense is just to bring them in federal district court and sue them, Title 42, 1983. Until you do that, until you actually lay that pleading on their lap, basically saying, hey, you're being sued in both your official and your private capacity, which makes them personally liable. A lot of times you're not going to get their attention. It's just the way it is, it's the way the system has been. This has been going on for 70, 80, 90 years, it's going to take a little while to fix, but there is remedy there. There's people that have done, like I said, have achieved incredible things out there with doing this stuff, and they're not using birth certificates, and they're not using trusts, and they're not using the all caps name. They're using standard legal procedure, and they're pummeling these people, because they're basically putting them back on their leash of what they're supposed to be. They're supposed to be public servants. And when you file against them, you sort of put them back on their leash, because they can't come answer you. They can't explain what they're doing, because when you start reading these tax codes and these statutes, you're going to find out that they're doing all kinds of things wrong. And not only are they doing all kinds of things wrong, they're taking statutes that were never written for you, that were written for corporations and businesses, and they're misusing them and applying them to you. And it has nothing to do with your all caps name and this corporation. It has to do with greed and incompetence and basically lawlessness, criminality. They're misusing statutory processes to violate rights and extort money from people. And it's really no more complicated than that. And when you get them in court and you sue them, none of this other stuff's going to come up. Believe me, trust me. It's nothing with the birth certificate and the all caps name. That stuff's not going to come up. What's going to come up is what's in the four corners of that pleading, basically. What you have on there. It says you should do this, you did this, and because you did that, you caused these damages. And that's real hard to answer when there's a procedure laid out for them and they're not following it. They have to have a reason for what they're doing, and they don't. They're not going to be able to answer it. So that's why you get a lot of these non-disclosures. They don't want to go to court. They settle out of court with a non-disclosure. And that's your goal. You want, your main goal is to have them leave you alone and leave your property alone. And anything that hinders you from that, any fringe issues that hinder you from that, or it's noise, it's nonsense. So don't get hung up on that stuff. Get hung up on, how do I hold these people accountable? Learn about torts and tort law, and that stuff we'll be going over. About assault and battery and negligence and harassment. Learn about that stuff and learn how to plead the elements of that stuff and how to put it in your paperwork. Because when you do it properly, you'll get their attention at that point when you filed against them. And that's when they're going to start leaving you alone, because it's not going to go well for them. So, but this is a quick phone call. This is a detective. This is the guy who started this all off. The attorney that originally started this off. He filed a withdrawal in the case, and a new guy came in. It's weird that the court still got his name listed up there, but he filed an official withdrawal. So I don't know if he's still involved in the case, if he pulled himself off the case. But it got a little weird because when I started accusing him of crimes in the paperwork, I think it got a little dicey for him, and they took him off the case. So it looks like the judge has been replaced too. I don't know whether that's sometimes they cycle judges around. But there's a new judge on the case too. So this is a criminal complaint that I filed with the district attorney. It's for official oppression, and many of your states may have the same exact statute. It's a pretty common one, official oppression. And really what it has to deal with is anyone that's depriving you of secured rights or privileges that you have. Anyone's denying you of any of that stuff. That's the crime of official oppression. I think in Pennsylvania it's Title 1853-01. So I filed it's a good catch-all crime because it encompasses your constitutionally protected rights and what the Constitution secures for you, the rights that it secures for you. So it's a good catch-all crime. It's usually what I start with, official oppression. And so I got a call, and like he starts off, and he's real hard to hear. But he was basically telling me that they investigated themselves and they didn't see any crimes. And that's where the phone call goes from there. And it's hard to hear where it ends. But he didn't hang up on me. It wasn't a hang up. He said, when I think the last thing I said was I started saying, well, hey, listen, I'm the only party with affidavits in this matter, and they're unrebutted. And I think from the gist of our conversation, he knew that I wasn't just some crazy free man on the land, running around making crazy claims, that the stuff I was talking about all had a legal basis, and that I was not going to let this go very easily, and I wasn't going to take his response basically saying that, oh, we've investigated ourselves and everything's fine. That wasn't going to fly. So he knew I was going to pursue it, and the way it ended, he said, let me call you back. And I'm hoping what that means is he's going to go ask some questions of the clerk, because you got secretaries and clerks over there in the Office of Judicial Support, which is the court's office, that are issuing judgments, and secretaries and clerks don't issue judgments. Judgments are issued after trials. Basically, you have a trial, and if you lose, the judge will sign an order. And say it's a debt case, and you lost a debt case, and the judge would sign an order stating you owe this debt. And then if you didn't pay that debt in the prescribed time, then it could be turned into a lien. But that's not what these attorneys are doing, and this is nationwide. They're running in and creating liens, and they're doing it under this, like in Pennsylvania, I think it's called the Pennsylvania Municipal Tax Lien Law. And that statute, when you read it, it's written for corporations and businesses. It's not written for me and you, because it can't be used for me and you, because right off the bat, if you execute the statute the way it's set up to execute, you would violate every man and woman's due process rights. So it would violate due process, the right to trial by jury. It violates all that. So by definition, there's no way that statute can apply to a man or a woman, because it would violate their rights right off the bat. So they're using this statute without any evidence that it applies to anybody. And like I said, this is nationwide. They're doing it in your state and whatever. They're all doing it in all the states. They're misusing that statute to try and get to basically violate your rights, and the main reason they're doing that is for financial gain. Okay, because they got the people dumbed down, and people don't know any better, and people don't read stuff. They don't read the statutes. They don't read the tax codes. So it's really no more complicated than that. It has nothing to do with the all-cap name attaching. It has to do with these local bureaucrat politicians and even the state people, that they're abusing these statutes to gain revenue. It's bottom line. It's all it is. So when you learn to challenge it, that's where your remedy's at. So here's the phone call, just a quick thing. Like I said, I'm hoping he goes and asks the clerk, because they issued a judgment from the office and nobody signed it. There's no judge that signed it. It says signed, and it says in print, Office of Judicial Support. Well, who's that? who says that? Mr. and Mrs. Office of Judicial Support. Who signed that? Because that's not a judge that signed it, and there was never a trial that was adjudicated for that judgment to have come. So, when he's telling me that these are not crimes, of course they're crimes, because there was never a debt established for there to be a lien created. The lien came from the attorney's head. He pulled it out of the statute. He looked at a statute and made a judicial decision on his own that that piece of paper applied to me and gave him rights in my property. That's illegal as the day is long. And this is what they're doing in all this stuff. They're doing this. So you just gotta, this is the stuff you call them on. It's really, like I said, it's not complicated. It's pretty basic stuff, and you'll hear it here in the conversation.
Speaking. Hi, Detective. How you doing?
So he reviewed it, he went through it. As far as he's concerned, there was no actual.
Oh, who said that? Who said there's no criminal code? Basically, well, wait a minute. How do you have an attorney without a trial forge a lien and file it? That man has no authority over this property. He can't walk into court and just create documents out of thin air. There's Article 1, Section 6, right to trial by jury is inviolate. You got to have a trial. You got to establish a debt before you can create a lien on it. You just can't create a lien out of thin air, and that's what these attorneys are doing. It's not my sewer bill. That's what I'm telling you. They didn't establish that it's a bill, that it's a debt. That's never been established. That's part of trial by jury. You just can't I can't go in and create a lien against that man's property out of thin air. Can't do it. Okay, he can't do it to me. That's the burden of proof on him. He's got to walk in there and do that. And in this case, guess what? I can't get the name of the person that signed the judgment at the court. Spoke to Mary J. Walk twice. She won't give me the name of the person in the office that created the judgment. A person in an office cannot create a judgment. Nobody can create a judgment without a trial. I mean, this is going to federal district court. This is a matter of, I just want to see how much stuff they're going to step in before I move it in there. But I mean, you don't call me up and tell me that's not a crime, that some guy walked into a court and just created oh, I don't care what the attorneys decided. The attorneys have no personal knowledge of anything in this matter. Well, they're all in the same group. They're all bar members. So you got a bar member that walked into court without a trial, without a debt being established, and he forged a lien out of thin air. Come on. Now, this is very simple stuff here. I can't walk in there and go, listen, Steve, I couldn't walk in and file a lien against your property out of thin air. They wouldn't take it, okay? I'd have to file a formal complaint against you, have you served a summons, and I'd have to send a process server out to your house to give you service of process so that you know who's making the claim against you and what the basis of the claim is, okay? Then we would have a trial. And then if you lost and I had a debt against you and you didn't pay the debt, then I could go file a lien against you. I can't jump to the lien stage and just go file a lien. You got to have a trial. It's established law, Article 1, Section 6. And it's also Amendment 7. Suits of common law, $20 or more. You got to have trials. You just don't have liens. And if somebody wants to claim that a piece of paper, a statute applies to me, it's got to prove that in a court of law. They just don't get to attach it to me because they have a bar number and they're an attorney. It doesn't work like that. That's not how law works. I know my way around courts. Trust me. Listen, I've been slow playing these guys for 2 years with this stuff. Now, listen, if you're going to go with an attorney's got no jurisdiction in the matter. He's got no standing in this matter. He's got no personal knowledge of anything that's going on in this matter. He's going to look at what another bar member did, one of his bar members, and make a judgment. Where do you think he's going to side? So what that guy just told you, the attorney, he just told you that a man, because he's got a bar number, could walk into a court and create a lien out of thin air because something somebody wrote that he has no personal knowledge of. He wasn't there when they wrote the statute. He's got no personal knowledge of the statute, and there's no way he could attach the statute to me. But that man, because he's got a bar number, he could go walk into that court and go create a lien out of thin air without a trial. And you've got Article 1, Section 6. It's established law. You've got to have a trial to establish a debt. You got to perfect the debt. And then if the debt's not paid, then you can lien somebody. You don't get to create the lien out of thin air. It doesn't work like that. That's not law. And these attorneys, they know this. They know exactly what they're doing here. Listen, they're abusing a statute under the color of law to deprive people of rights and to extort people. It's exactly what they're doing. How can somebody listen, you know judgments, Steve, have to be signed by judges. That's established fact. It's got to be signed by a judge. A secretary or a clerk in the Office of Judicial Support cannot sign judgments, okay? I've responded to things. Guess what? I'm the only party with affidavits in this matter. I've got 2 sets of affidavits in this matter, sworn affidavits notarized, that are unrebutted, unresponded. Listen, I'm going to tell you right now, this guy, Mr. Sheridan, he's headed for trouble when he goes in federal district court. He forged the lien. There's no doubt about it. He forged the lien. Listen, they can't circumvent a trial. You've got to have a trial in all matters. That's an established right. They don't get to circumvent that via statute. That's called a color of law. It's a color of law action. You can't supersede constitutionally secured rights under color of statute. That's what these attorneys are doing. I can't go in and go file a lien against Mr. Sheridan's property. I'd have to go file a formal complaint against him. I'd have to have him served, and then we'd have to have a trial. What he's doing, it's called simulating legal process. This is not the legal process, what he's doing. They're forging liens. And one of his buddies are going to look at it, his attorney buddies are going to say, oh, he didn't do anything wrong. No. That's not how this works. You've got to have a trial in all matters. That's a given fact. There's they can't get around that. That's Article 1, Section 6 of the Pennsylvania Constitution, and it's the 7th Amendment in the federal Constitution. Trial by jury is inviolate. It's guaranteed. How can we have judgments without a trial? How can somebody sign a judgment against me and they won't release the name to me? I can't even get a name from Mary J. Walker, who signed this judgment. She's the clerk of the court of County Delaware. She's the main clerk. Twice, she wouldn't give me the name. She won't give me the name of who signed this judgment. I don't know, and I don't care. It's irrelevant to the matter. The matter is that these people are making claims they can't support. They have no authority to be doing what they're doing. And I have no trouble going to a trial, but the problem is they can't bring me into court under a standard legal process because they don't have a cause of action to bring me in under. He can't file anything against me to bring me in under. So he's using this statutory process under color of law to do things he can't do. How can you violate due process? You know, this guy never gave me service of process. I never had a process server show up to serve me. I never even got a mailing. The first I heard about this case was when I got the judgment mailed from the Office of Judicial Support. First I heard of this case. No service of process, no nothing, no due process. Now I got some unknown clerk in the Office of Judicial Support creating judgments, which they can't do. Judges sign judgments. And that's after a trial adjudicated the matter, and then the judge can sign the order. You don't jump to. He's jumping from A to D. I'm sorry, Steve. Listen, I'm expecting you guys to like sort of put a, you know, when I hear you're taking advice from attorneys, that worries me. What's that? But that's the problem. See, listen, Steve, I'm just let you know. I know you have a job. Here's where this is going to go. I'm going to go file this with the special agent in charge of the FBI next. I'm going to go start throwing. I'm going to throw more state criminal complaints at you too, and I'm going to put you guys on the hot seat because I'm going to tell you everything I file in both the state and when I file with the special agent in charge of the FBI, that will wind up in that Title 42, Section 1983 pleading that I'll file in federal district court. Everything I do in this with these criminal complaints will be folded into that complaint. So this is all going to be reviewed. So if you're going to tell me that attorneys are deciding that other attorneys can walk into court and create liens out of thin air, I'm sorry, Steve, that's just not going to fly in federal district court. You've got to have trials. You've got to have adjudicated matter. You've got to perfect the debt. Then once the jury says, "Yep, you owe the debt," the judge signs an order. Then if I don't pay the debt, then he can go file a lien. He just can't walk into court and go create a lien. It's an absurd claim. And if he wants to claim that some statute or some ordinance gives him authority to do this, he's got to prove that in a trial. He just can't claim that something somebody else wrote applies to me. It doesn't work like that. Okay, that's not how law works. Law works on facts and law. He's got to prove factually that law applies to me. He just can't decide that on his own and go walk into court and file a lien, and then some unnamed entity in the court of Office of Judicial Support, they sign a judgment without any trial. Now here it gets worse, Steve. I've never had a trial in this matter. I never got service of process. And then they file it's called a writ of sua facie, which means basically pay us in 15 days or we're going to come take your house. Really? Well, that's extortion. Now we're at extortion right there, because not only did I not have a trial, I don't know who signed the judgment, and now I'm getting threatened by people, and I don't know who they are or where they're getting this authority to give me these orders without trials. Come on, Steve. And like you said, this is all. Listen, I was hoping that you guys would really put a good foot forward and look into this, because, like I said, Steve, listen, I didn't fall off the turnip truck. I know what I'm doing, and I got people around me that know what they're doing. I'm going to move this into federal district court. This is going to be, listen, this will be big when I move this into federal district court, because what they're doing, this is racketeering. This is not just a common thing what's going on with these attorneys. They're running into court and creating liens out of thin air without trials. And they're trying to do it under a statute, to do it under the Pennsylvania Municipal Lien Act. And they're not proving that applies to anybody. They're making a decision on their own without a trial that act applies to everybody. And they're forging liens, and it's on a wide-scale basis, and it's happening throughout Delaware County. And I'm going to listen, Steve, I'm in no trouble bringing this into federal district court and thumping them in federal district court. But I was expecting you guys really to put a good foot forward and do something with this. Steve, if somebody forges a document and files it against you, isn't that forgery? Okay, so what do I have to put a complaint of forgery in now? I'll happily do that. I'll put a forgery complaint and I'll write it up, because right now that's under official oppression what he did. Listen, it's established rights that I have a right to own and protect property, and that I have a right to due process of law. That's been violated from the start here. No service of process. This guy's making judgments on his own that certain acts apply to me without any trial. He's decided this. That's violation of due process of law. And he's creating liens out of thin air. There's no way, Steve, I could walk into court and go file a lien against that guy's house. I can't go look at some statute or code and say, yep, this statute gives me authority to go file a lien against Mr. Sheridan's house. All right.
So that's pretty much it. And like I said, will anything come of this? Probably not. No, but I'm just hoping that he does go to the clerk and just ask a couple questions, and hopefully gets her attention, because she knows who I am, and she knows that I've been kicking up somewhat of a storm about this, because what they're doing is it's just a total abuse of the process. And this is what they do in most stuff. Everything they're doing, these codes and stuff, they're abusing this stuff. These were not written for you and me. These were written to protect you and me, and they're abusing this process. So that's pretty much it. Just want to give you a little idea of, just hear like a real world conversation, how I deal with these people, how I talk to these people. All right, take care. Talk to you soon, and keep your head up. These people are not who you think they are.